All right, well, thanks very much. Happy August, everyone. This concludes our series on seminars in democracy reform for the summer. I'm very pleased to welcome you to this last one. We're going to continue these kinds of things in the fall, both in partnership with my on-campus group and also with the Electoral Innovation Lab, which is, as you all know, a newish organization that has become independent. If you want to read about what the Electoral Innovation Lab does, you can go to electoral-lab.org. I think that's the URL that we picked, and interns are like looking at me saying, yeah, I think that's right, electoral-lab.org. I'm Sam Wong, and I'm a professor here at the university. I am delighted to welcome our last speaker in this series, Nick Stephanopoulos. He succeeds several other speakers who have come this summer who have been all wonderful on different topics. Nick and Nick is a professor of law. He's the Kirkland and Ellis Professor of Law at Harvard Law School, and he visits us here by taking the Amtrak down. It was very nice of him to do so. I first met Nick in person at University of Chicago when he was on the faculty there at a little cafe called Plain Air. And he was surprised to hear from me because he had never met me before, but I really wanted to find people who knew a lot about constitutional law and specifically about election law. And I had very little sense of boundary, and so I wanted to go to someone who is a leader in the field, both in using quantitative evidence and also in the study of the law. And this path led me naturally to Nick. Nick is known, I think, mainly as a law scholar because of his many publications in constitutional law and especially in voting rights. Nick is also a leader in the use of mathematical methods from the social sciences in pursuing voting rights. And he has done a lot of work in that domain. I encourage you to read his work on the efficiency gap, which is a numeric standard that was proposed to pursue the question of whether a map has been unfairly gerrymandered to favor one political party or the other. This year, he has also worked on expanding the idea of communities of interest, which is an idea that is relatively recently expanded in the study of representational rights, and communities of interest may be very important in pursuing representational rights in the years and decades to come. Recently, Nick's scholarship attracted my attention because he's pointed out that with the weakening in the Voting Rights Act, the Federal Voting Rights Act, it is of interest to start pursuing voting rights at a state level, and he's interested in pursuing voting rights at the state's level, and basically using federalism as a tool for expanded rights. And he and Ruth Greenwood have an article in the Emory Law Journal, and that's forthcoming, and I encourage you to look that up. I'm hoping that the sound quality of this is all right. If it's okay, then we will continue. If you're having trouble hearing that, I encourage you to move forward because we have plenty of space in front. We'll have time for question and answer afterwards. I'm delighted to welcome Nick to campus and hope this will be the first of multiple visits to come. Thank you, Nick, for visiting Princeton.
Great. Thanks a lot, Sam. Thanks for that very kind introduction. So as Sam mentioned, this is a paper called Voting Rights Federalism that I'll be presenting today. It's a paper co-authored with Ruth Greenwood. She's the director of the now not quite so new election law clinic at Harvard Law School. She's also my wife and my frequent collaborator on both academic projects and litigation, and I guess also child rearing, among many other things. So thank you all for coming to this talk on a topic that didn't even really exist a few years back. So by voting rights federalism, I mean the emergence of state-level voting rights acts. This is really a phenomenon of the last few years. You can see here just a map showing where we have state voting rights acts across the country. They're highlighted in blue where such acts have been enacted. And in red, you can see some states where state voting rights acts, or SVRAs, are pending as we speak and might be enacted over the next year or two. Just as a matter of terminology, when I refer to a state voting rights act, what I mean is a state-level law or, in some cases, constitutional provision that tackles the same problem as the Federal Voting Rights Act, namely stopping racial discrimination in voting, but that goes beyond the protections of federal law. So what all of the SVRAs that have been enacted have in common is that they're more aggressive in one or multiple ways than the floor that's provided by the Federal Voting Rights Act. California passed the first SVRA about 20 years ago. That was the only SVRA for a while. About a decade ago, Illinois and Florida also passed SVRAs, but those were relatively meek. They didn't go much beyond the Federal Voting Rights Act. So it's only in the last 5 years or so that we've seen an explosion of really aggressive, sweeping state voting rights acts. Oregon, Washington, Virginia all passed their SVRAs within a year or two, around 2018, 2019. And then in the last year, New York and then Connecticut have passed the boldest SVRAs to date. And those are now the model for the bills that are being considered in New Jersey here, Maryland, Michigan, and elsewhere. Okay, so in this talk, I'll first comment on the drawbacks of the Federal Voting Rights Act. This is the impetus for this rise of state-level voting rights acts. I'll then cover what it is that SVRAs do. They basically try to respond to the drawbacks of the federal VRA. I'll then talk about the constitutionality of SVRAs. So why are they valid, notwithstanding some of the constitutional charges that have been leveled against them? And then the last thing I'll talk about are some ways to make SVRAs even more potent than the laws that we've seen to date. Okay, great. So starting with some drawbacks of the Federal Voting Rights Act, one major drawback is that the conservative Supreme Court is highly, highly skeptical of the Federal Voting Rights Act. In a 2013 case called Shelby County versus Holder, the court invalidated half of the Federal Voting Rights Act. The half that had required mostly southern states to get federal permission before changing any of their election laws. The court threw that out. The court has also narrowed the other half of the Voting Rights Act, Section 2, which creates a nationwide cause of action. Over and over again, that's been restricted by the Supreme Court. Because of the conservative court's hostility to the Federal Voting Rights Act, it's quite hard for litigants to win claims under the VRA, and that's another drawback of the VRA. Ellen Katz, who's a law professor at Michigan, tabulated every single lawsuit nationwide under Section 2 of the Voting Rights Act, and she calculated plaintiffs' level of success by decade. And you can see here that in the 1980s, the first decade after Section 2 took its current form, plaintiffs did pretty well, winning 2/3 or so of their claims. But ever since the Supreme Court got into the business of narrowing and tightly construing the federal VRA, plaintiffs' luck has changed. And so from the 90s through the present, only about 1/3 of lawsuits under the Federal Voting Rights Act have succeeded. So because of the hostile Supreme Court and because of the text of the Voting Rights Act as well, there are all kinds of substantive limits on Federal Voting Rights Act claims. One is that residentially dispersed or integrated minority groups are out of luck because one of the requirements the Supreme Court has made up is that only a geographically compact minority population can bring a redistricting claim. The Supreme Court has also held that claims for so-called crossover districts or influence districts are barred by the federal VRA. Crossover districts are districts where a minority group is less than 50% of the district's population, but is nevertheless able to elect its preferred candidate with some crossover support from white voters. Influence districts are districts where minority voters aren't numerous enough to elect their top choice candidate, but are numerous enough to contribute to the election of their second choice candidate, who's often a white Democrat rather than a minority Democrat. Claims for either crossover or influence districts precluded under the federal VRA. A lot of folks in this space, myself included, are proponents of different systems of proportional representation. Under the federal VRA, it's very seldom that any kind of system of proportional representation is imposed. It can only be imposed if a defendant jurisdiction is willing to accept such a system, and most defendants are not willing to accept those kinds of remedies. If you want to bring a claim of racial vote suppression or racial vote denial, the Supreme Court has come up with a series of factors, all of which are skewed in favor of defendants, which make it very difficult for plaintiffs to win those kinds of claims. And because of the Shelby County decision that I mentioned earlier, there's no longer the special preclearance process for the worst offenders, the jurisdictions mostly in the Deep South that had decades or generations long histories of racial discrimination in voting. So the impetus for state voting rights acts, for SVRAs, is to respond and to counteract all of these perceived deficiencies with the Federal Voting Rights Act. So how do SVRAs do this? Well, for example, most SVRAs drop the federal requirement that minority groups be geographically compact in order to bring redistricting claims. And so that means that residentially dispersed or integrated minority populations, here, for example, Latinos in the Los Angeles metropolitan area can bring claims under SVRAs while they would lose such claims under the Federal Voting Rights Act. If minority groups don't need to establish geographic compactness under SVRAs, what do they have to show to win a case? The two main elements are the existence of racially polarized voting, so major differences in the preferred candidates of minority voters as opposed to the preferred candidates of white voters, and underrepresentation for minority voters under the status quo. So that's what's left to prove for minority litigants under most SVRAs. Another thing SVRAs do is authorize claims for crossover districts and influence districts, so exactly the two kinds of districts that cannot be sought under the Federal Voting Rights Act. The image here is of South Carolina's 6th Congressional District, which is one example of a current crossover district at the congressional level. The 6th District is currently part of Supreme Court litigation that actually focuses on the district next door, not the 6th District. The third thing SVRAs do is authorize proportional representation remedies. Critically, not only if a defendant jurisdiction is willing to accept that kind of remedy, but also if the court in its own judgment thinks that's the most appropriate remedy for solving the problem of racial vote dilution. SVRAs also often name different kinds of proportional representation that can be imposed in such litigation. So they name, for example, ranked choice voting or cumulative voting. With multi-member districts, that's the form of voting that can enable the achievement of proportional representation. And a couple examples where, in fact, systems of PR have been imposed in SVRA proceedings are in Albany, California, and Palm Desert, California. Fourth thing that SVRAs do, only a couple of SVRAs do this, is make it easier for plaintiffs to win claims of racial vote denial or racial vote suppression. I mentioned before that the Supreme Court has pulled out of thin air a series of factors that all are tilted in favor of defendants. So on the other hand, New York, for example, has listed its own set of factors that are much more neutral and, if anything, are tilted toward plaintiffs rather than defendants. Connecticut has gone even further than New York by imposing liability for any electoral practice that causes a racial disparity. So any rule about voting that results in it being harder for minority citizens to comply with that requirement than it is for white citizens to do so. That's the most aggressive anti-racial vote suppression policy that's currently in place. And then the last thing that, again, only the Connecticut and New York SVRAs do is revive systems of preclearance like the one the Supreme Court struck down in Shelby County v. Holder. So Connecticut and New York have state-specific coverage formulas that target particular localities within those states that either have court records of discrimination or other indicia of discrimination, like extreme residential segregation or inequities in the criminal justice system. And Connecticut and New York tell those targeted localities that they can only change any of their election rules if they first prove to a state-level official that those changes won't have the effect of worsening the electoral position of minority voters within that locality. So this is how the federal preclearance system used to work before Shelby County. It's now been revived inside Connecticut and New York for certain Connecticut and New York localities. Okay, so SVRAs respond to the drawbacks of the Federal Voting Rights Act, and they go beyond the federal floor in all the ways that I've just talked about. This has prompted all kinds of allegations by critics of SVRAs that they violate the federal Constitution. In particular, that they violate the Equal Protection Clause by fixating too much on race. And so I'll talk now about why I think those allegations are meritless. So one kind of claim that's made against SVRAs, probably the most common kind of claim, is that they either constitute or compel what's known as racial gerrymandering. Racial gerrymandering is a legal term of art for a district that is drawn predominantly for a racial reason, and when doing so wasn't necessary to achieve some kind of compelling end. The diagram here is of the very first district in North Carolina that was ever struck down by the Supreme Court on racial gerrymandering grounds. So some critics argue that SVRAs either are themselves or lead to the creation of racial gerrymanders. One problem with this argument is that the racial gerrymandering theory applies to a particular district. It doesn't apply to broader laws that set forth criteria about districting. So, all the SVRAs that I've talked about are not themselves districts. They're laws that govern the creation of districts in some circumstances, just like the Federal Voting Rights Act. But that's not the kind of law you can attack as a racial gerrymander. You have to pinpoint a particular district and argue that that district is a racial gerrymander. There's sort of a category mismatch here, where SVRAs aren't the right kinds of laws to be attacked as racial gerrymanders. Now you might say, fine, even if SVRAs aren't themselves racial gerrymanders, maybe they necessarily or commonly lead to the creation of districts that themselves are racial gerrymanders. So that claim, I can at least wrap my head around it, but there's no evidence for that claim. In California in particular, we now have 20 years worth of litigation under the California SVRA. Hundreds of districts have been created or redrawn under the California Voting Rights Act, and not one of them has ever been found to be a racial gerrymander. So there's simply no evidence for the charge that SVRAs necessarily or commonly result in the creation of racially gerrymandered districts. Another kind of argument against SVRAs is that they rely on racial classifications, which, according to the Supreme Court, trigger strict scrutiny, which is usually fatal for the law in question. So to answer this charge, we have to know, what does it mean for a law to use a racial classification? The courts have defined a racial classification as a provision that distributes benefits or penalties to individuals because of individuals' race. And so if that's our working definition, there are two problems with the argument that SVRAs use racial classifications. One is that SVRAs don't allocate anything to individuals. SVRAs sometimes force jurisdictions to change their districting systems or their other electoral rules. But those jurisdiction-wide changes in electoral systems simply aren't individual level assets or penalties like a job or a house or admission to a school. And the other problem with this argument is that when SVRAs impose liability, they don't do so because of any individual's own race. Rather, they do so because of distinct race-related concepts, like the existence of racially polarized voting. And those concepts, it's true, they refer to race, but they're still not the same as an individual's own race. And that has to be the predicate for assigning a benefit or a penalty in order for a given measure to be a racial classification. Okay, the final allegation against SVRAs is that they're motivated or animated by racially discriminatory purposes. Purposes like that of the KKK marchers you can see in the picture there. Now here it's true again that SVRAs have race-related purposes. The basic aim of SVRAs is to fight racial discrimination in voting. But current law, at least until the current court changes it, current law distinguishes between invidious and benign racial purposes, and only says that invidious racial purposes trigger strict scrutiny. And so on the spectrum of invidious to benign, it's plain to me, it's plain to those who have thought about this issue, that anti-discrimination laws like SVRAs fall comfortably on the benign side of the spectrum. And note that if it were somehow the case that SVRAs had illicit aims, then so necessarily would the Federal Voting Rights Act, which has the same purpose of fighting racial discrimination and voting. And so would essentially all federal and state anti-discrimination laws, which fight either disparate treatment or disparate impacts in employment or housing or governmental contracting. All those laws have the same feature, that they're trying to fight some aspect of racial discrimination in voting. So I don't think there's any way to single out SVRAs with this legal theory. Rather, I think that this theory would necessarily also condemn essentially all American anti-discrimination law, which might be great in the eyes of some conservative judges today, but might also cause others to rethink a theory that has such radical implications. Okay, last thing I'll talk about is how we can make SVRAs more potent and maybe even more legally defensible than the laws that are currently on the books. So one thing that SVRAs could do is simply mandate or order that certain electoral policies be adopted by localities. Currently, all SVRAs rely on either litigation or something like the old federal preclearance process. Litigation and preclearance are not toothless, but they are slow and expensive, and they're piecemeal processes too. They go one locality by another by another. In contrast, a statewide mandate would just get you the electoral reform you're looking for instantly, statewide, in every single locality. For example, California, there have been hundreds of California Voting Rights Act lawsuits over 20 years, and after all of that effort, about a quarter of California cities have switched from at-large elections to districted elections. A simple mandate that every California locality has to switch from at-large elections to districts would have accomplished a lot more change instantaneously instead of putting us through this 2-decade-long lawsuit by lawsuit process. A second potential improvement for SVRAs is to require a plaintiff to offer a benchmark relative to which the dilution of minority representation can be measured or assessed. So the concept of racial vote dilution requires a benchmark. You have to assess the status quo relative to some other baseline if you're going to conclude that minority representation is diluted or bridged under the status quo. Every existing SVRA is silent as to what the right benchmark should be for this comparison. Is it proportional representation for minority voters? Is it maximal representation? Is it the best single-member district plan that some expert can draw? They're simply mute on this very critical issue. So our proposal is that a plaintiff always has to submit a benchmark, but the plaintiff has discretion to select whatever kind of benchmark the plaintiff wants. So this could be a different single-member district system. It could be a system of proportional representation. It could be more novel things. It could be a different election date. It could be a larger legislative chamber. It could be two school districts fused into a single school district. The benchmark could be anything as long as the plaintiff can then demonstrate that the status quo is dilutive relative to that baseline. The third potential improvement is kind of getting into the weeds now of how these cases work. So I mentioned racially polarized voting before as a critical thing that has to be demonstrated in most SVRA cases. SVRAs, like the Federal Voting Rights Act, contemplate racially polarized voting being shown through the analysis of precinct-level demographic and electoral data. The trouble is that those precinct-level methods don't work very well when you have only a few precincts, and that's common in smaller localities. And those methods also don't work very well when you have multiple racial groups or significant residential integration. On the other hand, surveys, simply asking individual voters who are their preferred candidates, and then determining racial polarization based on survey responses, that approach isn't subject to any of these difficulties. You have only a few precincts, no big deal as long as you can still get a representative sample of survey respondents. Significant residential integration, also major problem for precinct level methods, totally irrelevant for individual level data of the sort that you get from a survey. Last improvement I'll mention to SVRAs is maybe the simplest, just having them apply to all electoral levels within a state. So most SVRAs currently apply only to local jurisdictions, and in some cases only to certain kinds of local jurisdictions. And so our idea here is just have them apply to local and state and federal elections, just for the obvious reason that if you think SVRAs are good, if you think they're effective tools for fighting racial discrimination in voting, we might as well fight that same evil at every electoral level, and not only at the local electoral level. Last couple thoughts before I wrap up. One is that I know a lot about how SVRAs have been drafted. Ruth and I have been involved in the drafting process for a few SVRAs, but we actually don't know much yet about how the real world outcomes actually come out under SVRAs. And that's just because they're so recent. We have some experience in California over the last couple decades, but with the more aggressive policies that have been put in place by SVRAs over the last 3, 4, 5 years, there's basically no litigation experience, no academic studies of them, and so we're still kind of flying blind with respect to assessing the consequences of SVRAs. Second point is that essentially all of the states that have adopted SVRAs to date are blue states, states with unified democratic governments. And what that means is that minority populations, which are big minority populations in red or purple states, aren't drawing any of the benefits of SVRAs. So think of Latino voters in Texas or Arizona or Florida. Think of black voters in the South. None of those places have SVRAs or are likely to get SVRAs anytime soon. And so that's a big drawback with the federalism strategy if it's only going to work in blue states. But when you have lots of intended beneficiaries of these laws who don't live in blue states. The last, somewhat more hopeful point is that all of these state-level reforms could, in time, serve as a template for reform of the Federal Voting Rights Act. So we now have blue states kind of showing us that there's a real model for promoting minority voting rights beyond the one set forth in the Federal Voting Rights Act. When there's a large enough like-minded majority in Washington that's interested in revising the federal VRA, it's quite possible that these laws that I've talked about are going to represent the path forward for federal reform. So great, I'll stop there, and I'm happy to chat more about this. Thanks, everybody.
Nick, that was really great. Because we are, I believe, streaming this online, maybe it would be okay if we went to these chairs and then you and I chat, and I'll sort of direct traffic. I believe that either Mashad or Eric will manage, or maybe Ethan will manage microphones.
Excellent.
All right, very good. So that was really terrific. I wanted to just ask a few questions and then maybe open it up for discussion. Just some thoughts that have come to mind with this super interesting presentation. I am a little bit stuck on the idea that you've already flagged, which is how to pass a state VRA in certain states. So it's, according to your Emory Law Journal article, it's been passed in Washington, Oregon, California, New York, and Virginia, and Florida, I think. Is that right?
You say Illinois, and now Connecticut more recently, too.
Okay, so it's spreading, but those states, with the exception of Florida, are not known for, they tilt one way. And I guess my question for you generally, whether in a blue state, red state, purple state, this is sort of veering into the political. How do you persuade either legislators or voters that this is a thing that they want? I'm curious to hear you talk about paths to passage, whether it be legislative or voter initiative.
Yeah, great. So, so Florida, of course, is the one state up there that's not like the others. And Florida is also the one place where this kind of reform passed through direct democracy, through a voter initiative. The state legislators in Tallahassee had no interest in enacting this kind of a reform. And so proponents of stronger voting rights in Florida went over the heads of the sitting legislators. And so there are a number of states that have direct democracy, but that don't have SVRAs. Much of the rest of the Mountain West, Colorado, Nevada, Arizona, Montana. So any of those places, I think, are ones where a voter initiative could be a path forward, as it was in Florida. My other thought is that if these measures are really directed at localities that have substantial minority populations, they might not be that threatening to Republican state legislators. They're unlike statewide redistricting reform. An SVRA in Georgia or Texas is not going to threaten the Republican hold on statewide power. All it's going to do is alter the way that local elections are run. And so I'm not sure that Republicans need to perceive SVRAs as necessarily threatening.
I see, and sort of like home rule.
Yeah, yeah. It's kind of like let the localities that are minority heavy change their rules or have some lawsuits there. But like it's no threat to the statewide officials in Georgia if there's some lawsuits in Atlanta, or same point in Texas with the cities in Texas.
Is there a way to build consensus? Let's pick a state, like a red state where there is a voter initiative process, like Arkansas comes to mind. In a state like Arkansas, this is again getting a little bit past the law, like are there substantive arguments that would get a voter there to say, yeah, you know what, I think I'd like to vote for a state voting rights act? Like what kinds of arguments might be persuasive?
I have no idea how popular these measures are with the public, like none. I have some vague sense that because the Federal Voting Rights Act was reauthorized with huge bipartisan majorities over and over, there must be some substantial level of bipartisan support and popularity for these kinds of things.
You mean like the 1986 reauthorization?
Yeah, or more the 2000s.
Of course, what am I saying? Of course, right, the 2003 or whatever it was.
Yeah, so I think it's possible that these kinds of measures are popular, but I've never seen any polling on how popular state-level voting rights acts are. I think the pitch would be something like, look, intentionally or not, there's still a lot of racial vote dilution. There's still a lot of race-related problems in our elections. This is a step forward that, that through litigation typically enables some progress to be made. And don't worry, it's not going to upset the balance of power at the state level. It's just going to enable progress at the local level. So I think the pitch would be something like that. Tackle a problem without really threatening established power centers.
I guess the argument that you made towards the end, which is to basically let this pass it in multiple states and blaze a path to the future, it makes me think of something that comes up a lot when I think about modern politics, which is that as a nation, we're on this 50-50 knife edge, and there's this funny moment that we're in now where we've had, I mean, it seems like it's gone on forever, but a moment of close elections from Bush v. Gore till now. And that hasn't happened that often. The first Gilded Age, from 1876 to 1896, that was a time when we had a bunch of close elections in a row, right? Popular vote losers becoming president. And that happened with, I guess, Hayes and Harrison. Now we did it again with Bush and Trump. So it feels like just, I mean, this is just a purely statistical argument. We gotta be falling off that knife edge. And so at some level, what you're describing is a way of building the future. So we have to fall off the knife edge in the next 10 or 20 years because of demographic change. And you're describing a way where it could be possible to get change now.
Yeah, I think the key, I guess, insight is that when federal change happens, it's infrequent, but when it happens, it often follows trails that different states have blazed. And so, the Obamacare to some degree mimics the model of Massachusetts with an individual mandate for buying health insurance. The big congressional electoral bills over the last couple of years, their redistricting portions largely followed the model of the California Independent Redistricting Commission. I think people's imagination tends to be limited to what has actually been done by American states. And so now with half a dozen or more SVRAs, this is very much on the map as a real option for for American policy. And so I think you're exactly right. This is planning for a future where Congress can pass big laws with the awareness that whatever big laws Congress eventually passes are likely to be ones that replicate state-level efforts. So trying to build state-level examples for future congressional legislation.
Yeah, it reminds me of when Heather Gerken at Yale Law School writes about blue state federalism, right? The idea that you can apply rights and work for them at all levels. And where I think a lot of people who have grown up older and expecting the Supreme Court to be the parent who is strong and protects you and takes care of you. And now it turns out there's new dad who says, hey, your piggy bank is great for my beer money. And so there's like this other Supreme Court that's no longer the protector of federal rights. And so there's been this like flipping of states' rights as a thing, or state level authority being seen in the past as being bad for racial voting rights. And now you're saying flip it around the other way.
Yeah, I mean, it's clear there can be lots of negative, voting rights federalism developments too. Just look at the vote suppression and gerrymandering that goes on in a lot of red states across the country. So it's not an unalloyed good. I think the point is that federalism here can illuminate a wider range of possible policies, and some of those policies are terrible, but some of them are good. And so here I'm highlighting one genre of recent policy that I think is good, and that's only been made possible because of this commitment to enacting new laws at the state level instead of just waiting for the federal government to act.
You said something optimistic, which is you said districts drawn under this kind of mandate have not been in the past overruled as racial gerrymanders. And it sounded optimistic, but the Supreme Court's changed. And I'm wondering whether you have thoughts on whether, whether there are factions of the Supreme Court who might think that it might be time for a change, and it might be time to cast a colder eye on these so-called remedies.
Yeah, and you've got conservative litigants and advocates egging the court on, filing these lawsuits against SVRAs, filing cert petitions in front of the court, writing op-eds criticizing these laws. There's a constant churn of sort of conservative agitation against SVRAs. I think what is the strongest argument for SVRAs is that legally and conceptually, it's almost impossible, I think, to distinguish SVRAs from the Federal Voting Rights Act. Like, it's almost impossible to think of a legal argument that only applies to SVRAs and doesn't also doom the Federal Voting Rights Act. And as we just saw in Allen v. Milligan, I think
is that a bug or a feature?
Well, I think it now appears to be a feature for proponents of SVRAs in that I don't think John Roberts and Brett Kavanaugh want to tear down the federal VRA. And so if they're convinced that the logic that upholds the federal VRA is identical to the logic that upholds all the state SVRAs, I think that might foil the court doing anything significant about the SVRAs. The one bit of supportive evidence here is that the couple times that the conservative lawyers have filed cert petitions involving SVRAs, the court has refused to hear the cases. So,
just not agreed to hear it at all?
Yeah, these are not.
There are not 4 votes to hear it.
Exactly, not even 4 votes to hear it. So when a major conservative law firm filed a cert petition arguing that the California VRA is unconstitutional, and the court rejected that cert petition. And I think there was one other cert petition as well. So that tells me there's limited appetite on the court to tackle SVRAs.
Well, Toha, just to get away from the State Voting Rights Act concept that you're talking about, just to turn it to something that's happening right now, can you just review for people, there's this case in Alabama in which the legislature has passed a congressional a remedy a map that's supposed to be a remedy to a racial gerrymander, and it appears to be in defiance of the Supreme Court's, or rather the 3-judge court's order. And so there's still this firefight happening in Alabama, Louisiana, South Carolina is somewhat different, but same kind of idea, Florida. So your take is that those are going to go forward in a good way for proponents of voting rights?
Let me first just distinguish that context from this one, right? The beauty of SVRA litigation is that it just bypasses the hostile federal courts altogether, right? All these proceedings happen in state courts that are much, much more receptive to voting rights claims.
Right. Today you're describing a new path. I guess I guess I'm wanting a little bit of gossip about what's happening currently. I was sort of pivoting a little bit towards that.
Yeah, and so what's happening now with the defiant Alabama legislature, it's unfortunate. It's also not surprising. Like defendants, states really dislike giving up districts to the other side due to litigation. And so they fight this kind of remedy tooth and nail all the time. What's supposed to happen now is that...
Are you telling me that what just happened in Alabama is normal?
It's common. Maybe it shouldn't happen, but Ruth and I litigated a racial gerrymandering case in Jacksonville, Florida, over the last couple of years, where the exact same thing happened. We won. We got 7 districts tossed out at the city council level. Jacksonville came back and redrew a map that was almost the same as the invalidated map. So defiance at the municipal level rather than the state level. But our court just said, no, too bad, Jacksonville. Your new map doesn't remedy the constitutional problem, so we're not accepting it, and instead we're accepting fully one of the plaintiff's proposed maps. And so in our case, the city's defiance totally failed because the court didn't accept it. That's what will happen in Alabama unless the Supreme Court steps in and stops or slows down the proceedings. Without the Supreme Court getting involved, what's going to happen is like in a few weeks, the court will say, thank you, Alabama, for your proposed remedial map. Unfortunately, it fails to cure the racial vote dilution we found because there's still 1, not 2 performing black opportunity districts. So therefore, you have not enacted a proper remedy. We need to cure the problem. We're now going to accept one of the plaintiff's proposed maps instead of your maps. And that will be a court-ordered map since you, the jurisdiction, were unable to lawfully pass a remedy.
And both sides have proposed special masters, and seems like the three-judge court might pick one of those people. Yeah,
it's well accepted that the jurisdiction gets the first bite at the apple. But if that first bite is still unlawful, then we switch to a court-supervised redistricting
but they
process.
took that bite.
They took that bite, and they failed to pass a lawful plan.
Right. I want to open this up for discussion. Although the last thing is, you said a thing that I have to ask about, this clinic that you and Ruth Greenwood operated at Harvard Law School. I want to hear a little bit about that because it seems to be also part of a pivot towards local rights as a means of pursuing representational and voting rights. What's that clinic about?
Yes, the clinic, it's the country's first election law clinic. Law schools are full of clinics in other areas: criminal law, First Amendment, free speech, property, landlord-tenant, like you name it. There are law school clinics that focus on that topic. But for whatever reason, there's never been an election law clinic or law of democracy clinic until now.
Really?
Yeah. It's kind of there've been a couple. There's some centers at law schools that focus on law of democracy stuff, but they're not full-blown clinics that litigate and involve students in litigation.
And this clinic, what, files briefs and do you file lawsuits?
Oh yeah.
So you actually file you act like a law firm.
It's think of it like a mini ACLU, operating inside Harvard Law School. There's Ruth as the director. There are 2 full-time lawyer instructors who have significant voting rights experience. And then a dozen or so students per semester. So that's the team.
So it's like a pro bono activity except without the pro malo part.
Exactly, right. It's like a law firm doing this kind of work pro bono, but it's also like the ACLU or the Brennan Center doing this work with funding from a foundation, for example.
I see.
Here the funding comes from Harvard instead of outside donors.
Okay, I have to put on the Electoral Innovation Lab hat since I direct the Electoral Innovation Lab, electoral-lab.org. Where and how do you form alliances with people to do technical work? Like, do you have a network of people who help?
So Ruth and I, as litigators in academics in this space for a while, just have personal connections with people.
Around the country or in the Boston area?
Both, to some degree. One of Ruth's phenomenal ideas was buying out a political science PhD student every year and buying out the teaching of that person, and so having them on staff as the predoctoral fellow at the election law clinic. And so it's meant that for like, I don't know, $30,000 a year, we have like a razor sharp Harvard PhD student who can run in-house lots and lots and lots of empirical analyses for us. We've basically been hiring like Kosuke Imai's best grad students to be our in-house fellows. And that's been phenomenal. Ruth is a sort of inveterate networker, and so she knows lawyers, but also academics around the country, and is really good at involving people in our projects. And so I can say, on behalf of Ruth, like we're definitely very interested to work with the Electoral Innovation Lab too when a suitable project arises.
I will say from personal experience that Ruth Greenwood is a very good networker, and anyone who's come within, I don't know, 2 acquaintanceships of her, right? It's like 6 degrees of Ruth Greenwood, and so she is everywhere. So I should rather say the both of you are everywhere. That is really interesting. So this has been great. I would love it if we open it up to questions. If there's a microphone, please use it. I see Ethan holding it. If not, I certainly can repeat the question as needed. So any questions, comments, sentiments? I think there's one here.
I want to follow up on what Sam said, but also a comment you made about the Supreme Court. I do think that, anything that's happened before, the end of Trump's term was different than what's happened afterwards. But you said that you thought that both Roberts and Kavanaugh would not want to get rid of that, perhaps because they, fear the backlash. But could they further cut down the Voting Rights Act even without getting rid of it and kind of accomplish it that way? I mean, I'm really worried about them in other ways getting rid of it, or eventually getting rid of it completely, the Voting Rights Act.
They just had the chance to either cut back on or eliminate the one standing pillar of the Federal Voting Rights Act, which is Section 2. And what was probably the biggest surprise to me in my career as a legal academic, the court in Allen v. Milligan just a month ago kind of resoundingly reaffirmed the existing legal framework for redistricting claims under Section 2 of the Federal Voting Rights Act. So there were 5 votes, almost miraculously, to say that we are preserving, full board the existing doctrinal structure. Alabama had offered the court, 5 or 6 different ways to cut back on the federal VRA. And John Roberts, of all people in the United States, said no to every one of the options on Alabama's menu. No to the Federal Voting Rights Act being construed in a race-blind way. No to the Federal Voting Rights Act not applying to redistricting. No to the Federal Voting Rights Act being unconstitutional. No even to small bore restrictions, like paying more attention to whether the plaintiffs' proposed districts fully satisfied all of Alabama's criteria for districting. So Allen v. Milligan is, I don't know, a very strong indication to me that like John Roberts has done what he set out to do when it comes to curtailing voting rights. Like he wanted to get rid of the other half of the Voting Rights Act. And in earlier cases, he wanted to curb the effectiveness of Section 2. But he thinks he's curbed Section 2 enough now and isn't looking for further ways to curb it.
That started out so inspiring. You said it, this big surprise as an election law scholar and so on. Then you ended with, yeah, he thinks it's weak enough, and it's like it can just sit in the corner and meow once in a while.
Well, this is the brief that the election law clinic submitted to the court. Roberts relied heavily on this brief, which I wrote, and this was the exact argument of the brief. Like, look, evil conservative court, you've done enough. You've paralyzed, you've hobbled the Voting Rights Act enough. It's already a shadow of what it was. So you don't need to worry. It's not resulting in plaintiffs winning left and right. It's not resulting in proportional representation for minority voters, God forbid. Your past 5 cases limiting the act have really managed to hobble it. And he cited our brief for like 2 pages in a critical part of the decision. So it's not all roses and sunshine.
Yeah, I felt so happy during the first 30 seconds of your answer. All right, I'm back to baseline now. Okay, questions? Ethan from the Electoral Innovation Lab.
The microphone. I just have a question about the federal VRA. Since it does have compactness as a standard, what kind of evidence of compactness might a court look for?
Geographic compactness. Yes. For redistricting.
Yeah, what's a little funny with the compactness requirement in the Voting Rights Act is that the court has said that the kind of compactness it has in mind is the compactness of the minority population, not whatever district is or might be drawn enclosing that population. So the court has said that, but then on the other hand, everyone in these cases is always commenting about how either nice or ugly VRA districts look. So there's a strange kind of schizophrenia here where the official legal question is, are minority voters themselves concentrated or dispersed? But everyone kind of elides that question and goes on to the different question of, have you drawn a normal looking or ugly district circumscribing the minority voters? So there's weird slippage, like conceptual slippage in this area.
I have a question for you as a teacher of law students, and this will, I believe if I'm reading the room correctly, this will be the last question. I see constitutional law as, in some ways, the queen of the legal disciplines where, no offense to, I don't know, real estate law or contracts or what have you, there's a certain glamour that associates with studying the US Constitution and federal voting rights. And hearing you talk about this, there's this whole new frontier of dealing with state laws and state constitutions. At places like the Harvard Law School and other law schools around the country, are we about to get a wave of interest in state laws and state constitutions? Is that, like, what does it look like to suddenly have to, let's see, the Reddit meme is, instead of fighting a horse-sized duck, now we have to fight 50 duck-sized horses. And so I want to know whether you're now teaching about those teeny tiny horses.
Yeah, really interesting. I'm not sure it's the case everywhere that constitutional law is really the queen of law school fields. It was true at Yale Law School where I was a student, in particular at Yale. I'm not sure if it's true in the same way at Harvard historically. At Chicago where I was a professor, it certainly wasn't the case that con law was the preeminent field. Law and economics was probably the preeminent field at U Chicago. At both Chicago and Harvard, con law was not a mandatory first-year law student course until very recently.
Really?
At Yale, it was a mandatory first semester 1L course. But Harvard and two major law schools that did not put the same curricular weight on con law. But certainly for myself as a Yale law grad, though, I share your view that con law is the central, the foundational law school course. I'm not sure if there's a movement toward federalism necessarily. What there is a very strong movement toward is skepticism of hostility toward the Supreme Court. And so
Really?
on my own faculty at Harvard, 3 of my relatively young con law colleagues, all of their major intellectual projects are about why the Supreme Court should not have the last word when it comes to constitutional law, but rather Congress, the president, states, the people themselves, all should be able to independently interpret the Constitution and defy the Supreme Court when it comes to constitutional law. I haven't written much about this, but I put myself in that camp for the most part. That I don't believe in the court's exclusive preeminence when it comes to constitutional interpretation.
So intellectual respect for the Supreme Court there's a change in the air.
Yeah, so I would say 20 years ago, a few eccentric academics were making this argument. Still prominent people, but only a few eccentrics. This has now become a whole camp. The energy in con law among people under 50, I would say, is in this real hostility toward the Supreme Court. And this view that there are other valid constitutional interpreters out there with just as much of a claim to doing constitutional law as the Supreme Court.
That is very interesting. With that, I want to just reaffirm that our guest today, Nick Stephanopoulos, is a scholar who is looking forward in multiple ways, and you just heard yet another way in which he is looking into the future. Nick, thank you for sharing your time with us today, and let's take a break for a little refreshment.
Excellent. Thank you, Sam.
That was great.
That was fun.
That was great.